Hey, good afternoon, everybody. Dennis Mattern with Creative One here. I'd like to thank you for taking time out of your day to join us. I'll introduce my colleague, friend, and coworker here in just one second. But I want to talk a little bit about what's bringing us all together, and that is, of course, the Department of Labor. We're going to get into what's going on there. I do want to point out a couple things, though. If you look to the bottom right corner of your screen, wherever you're watching, joining us from, you'll see a baby kind of a robin's egg blue chat box. If you hit that box, there is a chat function that is available to you, and we will take a couple questions possibly at the end, depending on time here. Answer maybe a little Q&A at the end. But go ahead and if you have comments that you want to get in there, you can go ahead and put them in the chat. I will tell you, though, just a little bit of the ground rules. Chat is visible to everybody. So, if you've got a question and you want to get it asked and answered, throw it there. Just know that it's visible to everybody. If you do have a question, you're feeling a little bashful, you can utilize the Q&A function. I will be the only person that will see that. I will be your voice, your proxy in this presentation. Also, with that being said, we are recording, so this will be available to you later to review. And so going from there, let's get this party started. So first off, who is Creative One? If you are unfamiliar with us, I just want to take a quick second. Creative One, we are going to be celebrating our 40th anniversary coming up. We are an independent marketing organization. We work with independent advisors when it comes to non-registered annuities and life insurance, also registered annuity products. We do have a broker-dealer, Creative One Securities. We also have our own RIA, Creative One Wealth. And we have a fantastic in-house advertising agency. Our purpose is to work, support, and be the backbone of an independent independent advisors back office. So that's a little bit about who we are, but let's get to what we're here to talk about, and that is the Department of Labor. I'm Dennis Mattern, VP of Market Development here at Creative One. More importantly, though, I am joined by my friend, my colleague, and coworker, Andrew Payne. Andrew is a VP and General Counsel here at Creative One. He's also a board member of NAFA. I would dare say a guy who knows a lot about the Department of Labor. Andrew, welcome, sir.
Unfortunately, I know a lot about the Department of Labor, Dennis, but it's good to be here. This has been an issue that's been popping up a lot, really, the past 13, 14 years. And this is a big milestone, a big, seismic event in terms of how this industry and how specifically the independent insurance industry is going to have to behave and have to comply, coming in the next, couple of years. And so we're going to dive into that. There's a lot to get into. But I think most importantly, we're glad that you're participating with us today. We're glad that you're live with us today, because I think the more that you're informed, the more that you're involved with this early, the better you're going to be going forward in your practice.
Now, one thing that we always know is that when it comes to regulation, when it comes to really being in this space, we do know that we have rules and regulations, things that we need to comply with. There's always movement going on. And so now we have something new coming here.
Right. So that happened on Tuesday. That was Halloween. Certainly wasn't a treat. Feels like a trick, Dennis. But yeah, it came out on Halloween. And so we're going to dive deep into what we know so far on the new fiduciary rule that came out on Tuesday.
All right. So before we dive into where we are today, let's take a little walk through history. Let's go back. Give us a short history of what brought us here.
Sure. So I'm going to give you as best as I can, Dennis, the short history of the fiduciary rule in 60 seconds. No one wants to hear about it longer than a minute. So here we are. Someone start the timer. We're going to start in 2010. In 2010, in the first Obama term, they proposed a new fiduciary rule that was largely panned and largely viewed as unworkable. They went back to the drawing board. They came up with a new rule, proposed it in 2015. Independent insurance industry regarded as, a little bit of a burden, but didn't, 8424 was largely the solution there. Came back in 2016 with a different rule, a different final rule, that this was going to be the rule that was going to be out there. And it was completely unworkable for this industry. It was an existential crisis, Dennis, for this industry. We're talking the best interest contract. We're talking the financial institution requirement when independent agents didn't have a financial institution, as long as a whole host of conflict of interest rules that it seemed impossible to comply with. However, that rule was vacated in 2018 by the Fifth Circuit down in Texas. So Department of Labor goes back to the drawing board again. We'll call this the Trump rule that came out in December of 2020. This had a couple of things. They changed the definition of fiduciary. Or they reinterpreted it to include rollover advice if it's involved in ongoing advice or a future relationship. It also introduced a exemption called 2020-02, which is primarily used by broker-dealer registered reps and IARs of RIAs. Also a couple rules around compensation as well. So that's where we are now. But we knew that the Department of Labor wasn't done.
Wait. So that's where we were. That's where we were on what? Maybe
Monday.
On Monday.
On Monday, that's where we were. But we
Okay.
knew they weren't done. We knew that there was more coming.
Okay, so one of the things that we would need to talk about then, before we get to the rule, so we're still teasing just a little bit. Walk us through what the DOL had their eyes on, what they were targeting.
Yeah, so they forecasted this, or they foreshadowed what they were looking at doing in additional rulemaking, and that is, expanding the definition of the term fiduciary.
Mhm.
They've always said that they wanted to do this, that the 5-part test, this old test, wasn't going to work for what they wanted to do. So that's one thing they were targeting. The second thing is they weren't happy with 8424. This is the world where independent agents are living, is this 8424, and they said that they were wanting to level the playing field. Their term is leveling the playing field. So that we knew they were targeting that. Additionally, they were looking into some supervision. If you were a registered rep or you're an IAR of an RIA, there's some supervision element, including having that financial institution co-sign off. So they're looking at that for independent agents as well, like they did in 2016. And of course, they're trying to address compensation conflicts in whatever way they can. So that's where we are. But that's what they forecasted. With some, we'll get to it, but with some things, they largely hit each one of those in the new rule.
Okay, so that takes us. So that's what they've been focusing on. That's what they're looking at. That's what's their agenda, if you will. So let's talk about what came out on
Tuesday.
Halloween. Boom. We get the rule. What do we got?
Right. So when Dennis and I say the rule here, we'll either say the fiduciary rule, the new proposed rule, or just the rule. What we're really meaning is 4 different things that have been proposed. So we'll go through those, but just know that when we say the rule, we're referring to kind of everything here. And that's the proposed retirement security rule. And this is the part that amends the definition of fiduciary, that makes it this new broad, expansive term. It also refers to amending the prohibited transaction exemption 2020-02. Remember, this is for broker-dealer agents, reps, and IARs. And then it also amends PTE 8424. This is largely for the independent insurance space. And then on the last one, you'll see it proposes a whole host of amendments to different prohibited transaction exemptions that are in related but industries that are not connected to ours. And we're going to largely ignore that 4th bullet point for our purposes today.
So one thing I do want to throw out here, and I want to maybe take you back just a step, is I want to remind everybody that these are proposed amendments, they're additions. So you should, if 8424 or 2020-02, these PTEs, if these are something you've never heard of, then you really need to take a look at what you've been doing in your practice, because these have been there for a while now.
Yes, I mean, we've been living in a 2020-02, 8424 world since 2020, effective date 2021. So you should be caught up by now on that stuff. Your carrier should be working with you. Your IMO should be working with you. But that's where you need to be. But there's more.
Okay, so let's dive into this thing. So I'm a lay person, which means that I'm not required to have memorized all 800 plus pages of this thing. Now, you, sir, are an attorney, and you are, I would almost say, as close to a Washington insider as I'm going to get. Talk about key takeaways, because I know you've read every word of this thing, right?
Well, this is 800 pages, as you mentioned, Dennis. 800 pages is the length of a Game of Thrones novel, but these 800 pages that came out, there's no dragons, Dennis. But there is political intrigue in these 800 pages, Dennis, and so we'll get into that here with the rule. But just bear with us here. There's a lot that needs to be dived into in these 800 pages. There's a lot of nuance that's going to come out, but we want to hit the highlights in terms of how this is going to hit your practice.
Yep. Hey, I want to do, I hate to do this. I want to do a quick check. I see somebody in the comments said they can't hear me, but somebody else asked a question. I'm going to ask a favor of anybody who's listening. We've got a lot of people on. Can you hear me? I just want to make sure that we do have audio pumping through. It looks like it's good on my end. I just want to make sure. That we have. Oh, yep. I
Lots
love
of
it.
hearts. Lots of
Bob,
hearts.
thank you. Eric, oh my gosh, thank you. I appreciate everybody. I didn't know you could do the hearts on this thing. How fun is that? Okay, so let's get back into it then. Okay, so Andrew was just explaining to us that he had memorized this thing by every word, every single word.
Hey, Dennis, I promise you that I will have it memorized eventually, but not today. But I do know key takeaways.
Let's talk about them.
Okay, so I want to talk about 4 key takeaways today, Dennis. And the first one, and this kind of tracks what the department was targeting, is that I guess if you leave this webinar with anything, like this is the slide you need to know, and that the term fiduciary has expanded, and it's expanded to include one-time rollover advice. Under the previous rule, meaning the current rule, you're only a fiduciary. You only trigger a fiduciary status if you offer rollover advice in the connection of an ongoing relationship or contemplated future ongoing relationship. So it's a little murky. Do you fit that? Do you don't? This new definition just cuts away all that. If you offer rollover advice, whether it's one time or whether it's connected with anything else, it doesn't matter. You trigger a fiduciary status, and that requires a whole host of disclosures and obligations and methods of conduct that you have to perform.
And that's a good thing. Just to remind everybody, you see the word rollover. So we are only talking qualified money, Department of Labor addressing that money. So non-qualified money, not covered here by anything. But you should be, if you're putting one standard, honestly, you should be acting in that same way.
Yeah, right? I mean, we'll see how carriers treat this in terms of if they treat qualified and non-qualified sales separately. I could see there being some differences, but largely this is going to be the standard that you're going to be held to, if I had to forecast that. Just moving on to the next one, they have amended the 8424 prohibited transaction exemption, and we'll get into what these are in more details, but there's going to be more disclosures. There's going to be a rollover assessment that's going to be required, and that's probably one of the biggest elements and biggest hurdles that an independent agent is going to have to meet, and that's where, on this assessment that we'll get to, is where you need a good partner that knows how to do this.
It's going to be crucial.
Because this is something that an independent agent can't do on their own. That just the resources aren't there. Just to hammer the next two, supervision. So there is no financial institution required.
Define financial institution before you go any further.
Sure. A bank, a broker-dealer, a registered investment advisor, or an insurance company. Those are the 4 things that are financial institution. There is no financial institution requirement, a co-fiduciary sign-off by one of those 4 types of institutions. However, that's a win for industry. I would say that's a win. That's something that we feared that was going to be in this rule. But the insurance carrier of the product that you are selling will have to engage in some supervisory activities that we'll get into. Additionally, compensation always is going to be an issue, and they appear to have limited the types of compensation that insurance carriers can offer, and potentially third parties can offer. And there's a lot of questions around that, but we'll get into that later in this webinar, and then in the future. This is an ongoing and fluid situation.
We're very early in this ball game.
We're 2 days in, Dennis.
Yep. Okay, so let's dive. Let's go more into that fiduciary. Let's talk a little bit and expand what we got going on here.
Okay, so the fiduciary expansion, we talked on this a little bit in the previous slide, but I'm going to give you this. So there's 400 pages that explain this. I'm giving it to you in 2 bullet points, but there's essentially this. I'm giving you the gist, is that for what you need to know, fiduciary status is triggered upon one-time rollover advice. So if you're taking money out of a 401k, and you're putting it into an annuity, that will trigger a whole host of fiduciary obligations that we'll get to. So the test, more clearly, if you're into a math problem here, if you give rollover advice, you also receive compensation for that advice, and that advice is a regular part of your business. If you are in the business of giving advice that concerns rollovers, you give retirement advice, you give investment advice, you give insurance advice, you will trigger this standard.
Yep. Even if it's one time, I know that folks would get kind of hung up on that. Like, I'm not an advisor, I'm not giving ongoing advice, but we're saying here, hey, if you one time you're an advisor, or one time you're fiduciary.
One time you trigger that. And it's a word that gets thrown around a lot. You see it on commercials, you see it on people's business cards, what this term fiduciary really means. And I just want to be honest with everybody. It's not just another piece of paper. It's not more paperwork. It is a standard of care, a heightened obligation for the type of, really, we'll call it homework, the type of research and analysis that you have to do in order to perform this rollover.
Yeah, this is maybe an editorial comment on my part, but if you've been in business for more than a few years, that means more than likely you're doing it right. Now you just have to show your work is what at the end of the day. I could be wrong on that.
Right.
Okay.
It's showing your work and showing the rigor that you've put into making the recommendation.
I do want to pause for one quick second. We are going to do maybe a little Q&A because there's a lot of things rolling into the Q&A and such in the chat. I just want to remind you, we are recording, so we'll push this out when it's done. Also, there's a chat box. There's a Q&A box. It's in the bottom right corner of your screen. And if you type in the chat, everybody's going to see it. If you type in the Q&A, if you've got a question, if you type in the Q&A, that means you're feeling a little bashful, and I will be your proxy and I will ask the question. We'll talk about it later. Let's keep going though, Andrew. So what does it mean to be a fiduciary?
Well, that's right. So let's say you've done a rollover, or you've offered rollover advice, the sale has happened. This is what it means to be, or if the sale's about to happen, this is what it means to be a fiduciary. And this is the big one here. If you are a fiduciary, you cannot receive compensation. You cannot receive $1 based on that advice or based on that sale unless you meet an exemption. And the exemptions that are relevant to our industry are the 8424 exemption and the 2020-02 exemption.
I have to tell you, as just a regular common man,
I know these are just numbers we're throwing around
the
here.
Words like the PT, that it's an exception to get compensation. It's all very, no offense, because I know you have a degree in law. It's very lawyer language.
Sure, I will explain it as if you, Dennis, not the folks at home, but if you, Dennis, were a fifth grader here, you cannot get paid unless you meet this standard, unless you do some more work under one of these two, 8424 or 2020-02. Just, we'll call it option A and option B. Now, on 2020-02, that is for broker dealers and for RIAs. So if you were with those firms, be reaching out to them to see how they're going to comply.
Yep.
They may offer 8424, and we'll get to whether that's available or not. But if you're an independent insurance agent, 8424 is going to be your method to get paid. You're going to have to comply with these disclosures and obligations in order for you to receive $1.
As the new rule states.
Yeah. The other things that it means to be a fiduciary is you've got to abide by the best interest standard of care. You can receive only reasonable compensation and have no materially misleading statements. A little alliteration, hard to say. So those are the big things that it means to be a fiduciary. We're going to dive into these exemptions now and the changes that, because we want to get you paid. Like, this is hard work that you're doing, this valuable service that you're providing. You've earned that commission. This is big lifetime trust that they've put into you. You have that nest egg, and we're trying to take care of that.
And we're not working on grant money.
And we're not. So we do believe in compensation in this industry. So we want to make sure we're abiding by the rules in order for that to happen.
All right, let's talk applicability.
Sure. So 8424 has been limited by this new proposed rule. It's only available to independent insurance agents. And here's the key part, Dennis, who are contracted with 2 or more carriers. So they basically gave us a carve out. They basically gave this industry a carve out. So if you're an independent insurance agent, you can use the 8424 exemption. No one else can. This used to be a widely used exemption, and now it can only be used in this industry. The outstanding question, though, is whether the 8424 exemption will be available to IARs of investment advisors or registered reps of a broker dealer. We don't know. It's very unclear in the language, and I'm sure that's going to be cleaned up in the future, the final proposed rule. But something we'll be asking, something we may call up the Department of Labor directly and ask, did you intend this? Because the language isn't clear. So more to come. We'll be on this channel here through Creative One answering these questions. But I'm putting it out there. That's an outstanding question. Now, outstanding not meaning great. Outstanding is unanswered, Dennis.
So I've got two questions to ask you back on that. So as it stands now, as it stood on Monday before this rule came out, and we're going to talk about timeline with this thing because this is not done. But as it stands Monday, if you were an IAR, if you're a registered rep of a broker dealer, the odds are you're using 2020-02.
Correct. The odds are your RIA or broker dealer has decided to use 2020-02. It was for folks like that, it was a little easier. You didn't have to disclose comp. You didn't have to do a couple of these other things. The choice, if 8424 is going to be available for IARs and registered reps, that becomes a more interesting choice because they're a little bit more aligned now. So maybe it depends on how it shakes out and what these firms decide. So once again, question that still needs to be determined and how we're going to shake out. And
then just for anybody, because before in my past, I was a captive agent. So with just the one company. So if you're sitting out there and you're thinking, man, I tend to like to use just one or two companies, maybe I'll just drop it and go to one carrier. They've got that blocked off.
Right. And this definition here, if you want to be considered an independent insurance agent and you want to utilize 8424, you've got to have multiple contracts.
Okay. So speaking of the 8424, so let's talk about the requirements and what they're thinking.
Sure. So here are the disclosures. So a couple of these are already included in the 8424, but these are expanding these greatly, actually. So the first one is that you have to disclose your fiduciary status. You have to affirmatively tell your client that I am a fiduciary and I'm acting as a fiduciary in my capacity towards my advice towards you. That has not been required so far. The second is that you have to abide by the best interest standard of care, and you have to tell the client that I am acting in your best interest in this transaction. The next one has been required in the current 8424. You're required to tell the types of products and services that you can offer. So if you're an independent agent with multiple carriers, you need to say this. The difference here, and this is a key one if you want to take anything away, is you have to tell all the carriers that you're able to offer, and you have to tell all the products that you're able to recommend. That seems to be a big lift because some carriers may have a whole host of products that you may be eligible to sell. So, I don't know how that's going to shake out, but I imagine there's an appendix attached. Like this is all that I can sell, and you'll have a good IMO to work with that can help you put something like that together.
At first blush, that seems like that's ridiculous. There's, I represent, I'm contracted with 15 different companies. Each company has 15 products. But I guess, at the end of the day, like you just said, it'll be an appendix.
That's what I'm just throwing that out there. It's going to be difficult to is anyone going to read through all that? I don't know, but it's good. That option is going to be there for the client.
Yeah.
The last two, just to hit on, the first one is the right to receive additional information. This is mostly about compensation, about fees, about other types of financial information. And the last one is that you have to affirmatively give the client written down your best interest recommendation. And you have to tell the client, this is why I'm recommending this product to you, and that this is why it is in your best interest to do this rollover and to make this or to buy this product.
So we're talking narrative form, probably.
Could be narrative form, could be a couple other ways. It's what's going to be required in that. It may depend carrier by carrier, but I imagine narrative could be a valuable thing in this case because that shows particularized, individualized that you've done the work for each client.
I want to back you up. Fourth bullet point. Did we hit the percent and dollar amount?
We didn't. That one's also a big one.
Yeah.
So compensation, you currently under 8424 do have to disclose compensation, and you can do it by percentage. So the percentage of premium. In this one, you have to give compensation in percentage of premium and dollar amount. So that's a big lift. That's a big step forward. I mean, a lot of people are going to be uncomfortable with that, but that's what's in the new rule.
Will that be something that I'm peppering you with questions?
It's okay.
Here, but if we've got the commission, we've got it in our for advisors that are working with us, we've got that commission calculator. That would probably build right into that, wouldn't it?
Yes. Okay. It will. You'll need a tool because having to look that up manually is going to be very difficult.
Yeah. And that does bring up some challenging questions of one never knows how much funds actually ever roll over the exact amount. What's going to be the what's going to be the threshold, or lack of better words, wiggle room. I mean, that's A lot of interesting questions here on this proposed rule. So let's take it over to that rollover assessment. I think that's interesting.
Yeah, so this is a big one. This this assessment looks similar to what's required under the current 2020-02, what current IARs and broker-dealer reps do. And so you've got to give a comparison. You've got to give them a document that's a comparison between the current plan, let's say their 401k, and your recommendation. And that's the analysis has to include, and that analysis comparison has to include alternatives to the rollover. Like these are other options you can do instead of doing this particular rollover. You've got to compare fees and expenses. This is the difficult part. You've got to be able to look up what the fees in the 401k are. Insurance agents in the past haven't had to dive into the particular 401k's information that they're rolling out of. So they're going to have to find that information. There are tools out there. You need to find a good partner that's going to help you to find those tools to get that information, because it's now going to be required. And then a couple other ones you need to address, who pays administrative fees and expenses, and then explain, plan differences. And, those plan differences could be, differences in, fiduciary status, the types of services and the types of products available, that are available in the plan, and then what are available once you roll out of the plan.
Yeah, the first sub bullet point is going to be one that it will be interesting to watch the alternatives to the rollover, as far as what depth an advisor will have to depth and breadth there.
Sure. Unknown at this point. I mean, there'll be guidance that comes out from the Department of Labor, and probably where it's going to come from, where you're going to see it is from your carrier.
Yeah, absolutely. Okay, so that takes us then to, you mentioned carrier. Let's talk about this new role of carrier supervision, this new / old role of carrier supervision.
Well, I mean, there's some carrier supervision now. I don't know if you'd call it supervision, but they do perform a suitability review, a due diligence review that was, existed for quite a while, and has existed under the new best interest, model rule best interest at the state level. But there's more to it than at this level. And so the carrier has to perform these obligations that include authorizing and analyzing each sale to make sure that it complies with the impartial conduct standards, or complies with the rule, to ensure that it's compliant. And then they've got to have a whole host of policies and procedures that materially, or that mitigate conflicts of interest. And then they've got to perform a retrospective review annually. So they're going to look back through all the sales that happened through qualified money, to look for errors, to look for compliance issues, and then fix them if they find anything. But it's important to note that insurance companies are not co-fiduciaries like they have been, or the fear was in the past. So that liability doesn't exist as much so on the carrier as it could have been. So that's a win for the industry and a win for carriers at that small level, if we're looking for rays of sunshine here. Something we were interested in. So they're not considered co-fiduciaries, but they did enhance the supervisory obligations on their part.
Does this mean, so I'm gonna put you on the spot, and it might be hard because I know you've been 2 sleepless nights reading this thing. So it's as far as hanging on to documentation, since that third bullet point talks about retrospective reviews, if I'm not mistaken, 6 years?
Still 6 years. Yes. You've got to hold on to the whole host of everything that you're supposed to give to the client. We're talking your disclosures, your rollover assessment, and anything else that's going to have to be held on to for 6 years.
And so the you in that sentence, though, is the independent advisor.
Correct.
Okay.
Correct. Now the carrier is going to have their own obligation, but you as an advisor have a 6-year obligation to hold on to that paperwork.
All right. Now, I think we need to talk about maybe one of the, the biggest elephant in the room, which is compensation. What does this do?
It's unclear, but what we do know is that this rule does appear to limit compensation to merely carrier commissions. So carriers are probably not going to be offering, or probably won't be able to offer, incentive trips. The other incentives from carriers, unclear of how that's going to shake out, but it seems to be that the only thing you can receive from a carrier is your straight up commission. And then this is probably targeting revenue sharing, maybe marketing dollars, other types of incentives, likely to be diminished or go away under the current iteration of this proposed rule.
Be interesting to see how that one shakes out, because there's still a long way to go.
Long way to go into how this is going to be interpreted, into what the final rule is going to look like. But it looks like they're taking aim at compensation. More to come on what that actually means.
Mhm. So I guess let's talk. We keep saying more to come. Let's talk about what's next. Walk us through that.
Okay, so we have a proposed rule. This is merely a proposal. All the department has to do right now is they have to say, hey, this is something we want to do. We want to take comments on it. They're obligated to have the public offer comments, and they're giving the public only 60 days to digest this and offer comments on it. And you better believe that Creative One will be offering some choice comments on this rule, Dennis. And we'd like to encourage you to do that as well. So if you are interested in participating and engaging with the department on this rule, we want you to reach out to us, and we can point you in the direction of the best way and the way it's going to be most helpful. So more to come on that. We'll reach out to get you those measures. So 60 days, we're talking just after the first of the year. This actually will be published, make it made official tomorrow. So it'll be 60 days from tomorrow.
Will it be any different than what was put out?
No, just with dates plugged in. The
Okay.
only difference that will be. So then they will, after the 60 days, so we're talking January 3rd, January 4th, they will consider those comments. They will then get to work on a draft final rule. They will send that final rule to the Office of Management and Budget at the White House. They will take 30, 45 days to review. So, and then a final rule will be published. And the department has indicated that they will make this rule effective 60 days after the final rule is published. So, I mean, that's a lot of days and timelines, but what you need to know is that they're shooting for a final rule publication probably somewhere around July. So that means that an effective rule will have to abide by a new rule. If they have their timeline go according to plan, we're thinking maybe sometime in September, quarter four, maybe early quarter four. That's where we're shooting for here. So that seems like it's kind of far off, Dennis.
Right around the corner.
It's not.
Blink
It's
of an
not.
eye.
We need to be starting now in terms of getting our compliance,
Our house is in order.
our house is in order. So yes,
And
but
our tools. But will there be litigation, Andrew?
well, you spoiled it here. The answer is yes. There will likely be, and there will most likely be litigation on this, and that's just because the rule that they designed in terms of how a fiduciary is defined is just so close to how they defined it in 2016 that it's going to be challenged in the courts. I mean, it's too close to what the courts have already said is not acceptable. So I think the department knows that, and they're willing to challenge it. They're willing to, maybe they'll get a better result this time. But I think that if you put the old rule that was struck down and compared it to this one, in terms of how a fiduciary is defined, it's not that much different, but they're willing to go to the mat to see if they could come out on the other end on top. And so it'll be a struggle. Now, litigation likely could push this back a little bit in terms of the timing that I just described, in terms of, final rule published in July and then effective maybe in October. That could, or September even. So that could push it back. But I mean, largely, let's view this timeline and then understand that there could be bumps in the road that push that out.
It's nice as a taxpayer to know that they're pushing out something that's very similar to what was pushed out years ago and was defeated.
Hey, we'll see what happens. It's going to be interesting. There's already been trade groups and companies themselves who have indicated their willingness to fight this. I don't know when that'll happen. It may come, once the final rule is proposed. So we're thinking maybe, March or I mean, when it hits the register, or I don't know, but we're thinking March, April, May, it could come to litigation. So we'll see. I mean, there's a lot more to come.
There's a lot of people that are not fond of what was just proposed.
I would say that there's quite a few.
Yep.
Dennis.
Okay, so I want to get preachy for just a second, and you're probably wondering right now, what should you be doing? What could you be doing? And I will say this, as an independent advisor, one of the things that you cherish and one of the things that makes you incredible is the fact that you are an independent entrepreneur out there by yourself. That's also a problem. There is strength in numbers. So I would challenge you right off the bat. Are you a member of any trade group where you're putting your voice, your dollars, a little bit of your time into making sure that the business that you're in, you stay in business, and that it's ruled fairly. So there's some great organizations out there, NAFA, NAFA. Gosh, we were talking off camera.
FinSecA, or Insured Retirement Institute, or Big I, the Insurance Association. All those are going to be involved in this. They may even team up to form one big joint trades group that does something. But they're all seem to be on the same page.
Yep.
This is unacceptable, and this isn't going to work for us. But if that happens, we'll be ready.
That's right. So the other thing you can do, review, take a look at your practice right now. And if you need some assistance with this, reach out to us here at Creative. But you need to review, what does your CRM look like? What does your retention policies and practices in your office? What does your file system look like? Make sure that house is in order. You also keep an eye out. We put out C1 Insiders, what we call it, when there's when we get pressing news, we're going to get it pushed out ASAP. So keep an eye out for that. Also, I would urge you and strongly recommend that you go and bookmark. It's www. I don't know if I need to say that anymore, but I'm getting old. creativeone.com/DOL. We have a resource page, a repository of information. That's where we're going to drop FAQs. That's where we're going to drop information as it comes out, so that you can you can go use it as a touch point. You refer to that for you and your practice. And I think that falls right in line, Andrew, with I think our pledge. And we pledge this to you.
Well, we want to be excellent in any regulatory environment. We're going to be ready if this thing goes full force. We're going to be ready if it goes away. We're here at Creative One, seek to understand and become the industry leader in how to comply with this in the most effective and efficient and least cost-consuming way. So that's what we want to do. We're here to be excellent in any regulatory environment.
That's right. Because you know what? No matter what, if this one goes away, we're still in a regulatory environment because we've got rules we have to follow. So with that being said, that brings us to the end. We are going to, Andrew, if you're up for it, if you do have a question you want to throw out, we'll answer it to the best of our abilities. I do want to temper expectations. This doggone thing is 800 pages plus, and it literally just came out. So if you're up for it, Andrew, I will. Let's walk through. I'll shoot you some questions here, and we'll walk them through. So if you have a question, you type it in the chat box. We'll go for just a few minutes here, or if you're feeling bashful, hit the Q&A, and I will be your voice in this. So let's take a look here. And again, I just want to remind everybody this is early. So Andrew, does this rule affect life insurance sales?
This does not. It's annuities only.
Okay. What about if funds go from if somebody goes right into a life policy? Is there any?
It would depend on the policy. I mean, this is really targeted at annuities.
Okay, so we'll keep an eye on it. Speaking of that, I want to go back just for a second. A couple days ago, we watched the press conference from the White House. It seemed kind of inflammatory. We're working on some FAQs for what the White House was saying, because they mentioned annuities specifically several times.
Yeah, if you were to watch the press conference at the White House and to read their fact sheet, you would, anyone familiar with the industry would recognize the whole host of misstatements and misunderstandings. And I don't want to say lies, Dennis, but there were mischaracterizations of this industry up and down.
Let's go mischaracterizations. That's nice.
Sure.
A nicer way to say that.
There was, in so much to the extent that the National Association of Insurance Commissioners, so these are our regulators at the state level, stood up to the White House and said, no, you are wrong. You were wrong about how you're characterizing how this industry is regulated and how this industry operates. So, this is your state's insurance commissioner has said, excuse me, Department of Labor, excuse me, White House, this is too much. You're misunderstanding what's going on. So this is a product that we believe in. Dennis, you and I are here because we believe in this product. We believe that this product has a valuable place in a American Savers plan or American Retirees plan. We believe that, offering downside protection, offering longevity protection are valuable things that can provide it to the American saver. And so we're not going to stand for this slander on the industry, and we're going to stand up for it. We're going to stand up for it in the media. We're going to stand up for it, as we talk to and describe what we do to folks in the public. So we're here because we believe in this product, and we're not going to stand for that type of type of talk.
It was funny to listen to that press conference, and it was honestly, it felt I would use the word inflammatory. And then you read the rule and it seems pretty. I don't want to say reasonable, but way two different vibes off these things.
You would have thought they were going to ban fixed indexed annuities
Yes.
as a result of the press conference.
Yes. Okay, let's hit a couple questions here. So one of the questions that popped in here was, hey, I'm an IAR, I'm an independent agent. Which am I?
Yeah, we don't know. We don't know how this is going to work yet for IARs. It's very unclear about whether an IAR will have to comply or can comply with 8424. But at the end of the day, you'll have to comply with 2020-02 if 8424 is not available. And that's going to look very, very similar to what we just described with 8424. It's all those disclosures. It's going to be that rollover assessment. That rollover assessment you should already be performing if you are an IAR.
Gotcha. Perfect. Let's see. Someone asked how likely are these changes going to be shot down in court? Knock on wood. Hopefully, pretty.
I can't forecast that. I don't know. It's good. We'll be challenged. I don't know what the outcome is going to be.
Perfect. Okay. I saw a comp question. We covered that in the content. Going back up. There's a long one here. I'm going to table that one. We'll talk about that, and I'll reach out to you, the person that asked that question. Satish, that one's a little long for us here. Does the fiduciary definition require the advisor rep agent to have a Series 65 license, or will the 8424 documentation cover that for the agent and lay up for you?
Yeah, you don't have to have a Series 65. You can continue to exist as an independent agent that just has an insurance license, and you can use 8424 in that purpose.
Here's one. I think this is a matter of semantics, but does this proposed rule only apply to rollovers or also non-rollovers, IRA to IRA transfers?
I think that the interpretation it includes IAR or IAR. Excuse me. Hold on. A lot of IARs, RIAs here, Dennis. But from IRA to IRA, yes, it does require that additional rollover assessment.
So if it's
you got to compare previous one to the new one.
If it's qualified money and it's gonna be in there.
Yes.
Let's see. Question, does Creative have a model file? I'd love to have an example of a proper file to keep.
We would love to offer some compliance assessment work for you folks. So if you have concerns about this, we'd love to talk to you about it.
Yep. Somebody, question, doesn't sound like no advice will be an option. What do you think? I think the answer is probably no on that.
In terms of if the client wants no advice, or...
I guess we could hypothetically, Chip, if you want to fill that in just a little bit, or I can take a stab at what I think. Maybe somebody comes in and says, "Hey, Andrew,
this is what I want."
This is what I want. Write it up.
Couldn't still be an option. There are folks who walk in and say, "This is what I want. I want you to do it." We'll see how that works. You'll have to really document that, but stay tuned. Don't change your practice as a result of this yet.
Yeah, so where that would probably really hit would be like the maybe the discount broker or the guy that just reaches out to, I don't know, self-roll. I guess I don't know. There's some interesting things here. I think, Andrew, that takes us. I think we hit the questions that are in here.
Well, there's a lot of questions,
yeah.
Dennis. I have a lot of questions that I would like to ask. But I'll ask you all at home that are in your offices or at home, wherever you're listening, stay tuned to us. We're going to be on top of this. We're going to be, the moment something comes out, we're going to dig in and do our analysis. And we're also going to be building out some compliance programs to get you at least prepared to get prepared. It's always best to start as early as possible. So when compliance date comes, you are set up for success. Anyone who's scrambling to do this at the end is not going to have a successful business at this.
That's right. Okay, so with that being said, I think that's a great spot for us to stop. With that being said, I will get out a copy. I'll do the little edit trim on this, and we'll get a copy of today's recording out to you. We will make sure, as our slide said before, that we will be excellent in any regulatory environment. We take that serious because we love the independent advisor, and that is who our client is. And we will make sure that we keep you in the good graces of all the churches. So with that being said, on behalf of Andrew Payne, Andrew, thank you, sir.
Hey, good to be here, Dennis.
On behalf of Creative One, on behalf of myself, I thank you for taking time from your busy schedule to join us. And we will take that serious. We will make sure that we keep you informed of anything that you need to know with your practice. If we can be of any assistance, please let us know. With that being said, that is the end of today's webinar.